Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. The appellant has been accused of enticing a 7-year-old girl to accompany him on the pretext of picking fruits, having thereafter committed rape upon the child, having caused her death, and having dumped the dead body near a bridge on the river bank after having dragged the dead body over a distance of 1 and 1/4 kilometers. The prosecution case rested on circumstantial evidence to the effect that the victim was lastly seen in the company of the appellant, that her dead body was recovered at the instance of the appellant, that the appellant had failed to satisfactorily explain his whereabouts and his knowledge of the location of dead body, and that the medical and other scientific evidence was consistent with the accusation. Per contra, the appellant alleged that he was falsely implicated due to enmity with the families of the deceased and other witnesses because of a land dispute. Next day, the learned additional sessions judge heard the accused and the prosecution on the question of sentence, and looking to the heinous crime committed by the appellant, found it unjustified to show any mercy in punishment, and thus awarded varying punishments, including that of death sentence for the offence under Section 302 IPC. We may proceed to deal with the question of sentence in the present case while keeping in view the principles so evolved and applied by this court. It could at once be noticed that both the trial court as also the high court have taken the abhorrent nature of crime alone to be the decisive factor for awarding death sentence in the present case. As noticed, the trial court convicted the appellant on 7/12/2016, and on the next day proceeded to award the sentence. The impugned sentencing order of the trial court does not indicate if the appellant was extended reasonable opportunity to make out a case of mitigating circumstances by bringing relevant material on record. The sentencing order also fails to satisfy if the trial court consciously pondered over the mitigating factors before finding it to be a rarest of rare case. The approach of the trial court had been that the accused appellant was about 33-34 years of age at the time of occurrence and was supposed to be sensible. The trial court would observe that if such heinous crime is committed by him, it is not justifiable to show any sort of mercy in the punishment. The High Court, though, has made rather intense comments on the meaning of rape and brutal murder of children, as also on the society's abhorrence of such crime, but has thereafter proceeded to confirm the death sentence with a cursory observation that there were no substantial mitigating factors and the aggravating circumstances were aplenty. In other words, the impugned orders awarding and confirming death sentence could only be said to be of assumptive conclusions, where it has been assumed that death sentence has to be awarded because of the ghastly crime and its abhorrent nature. The tests and the norms laid down in the relevant decisions, commencing from those in Bachchan Singh Supra, seem not to have acquired the requisite attention of the trial court and the High Court. It would have been immensely useful and pertinent if the High Court, while taking up the question of confirmation of death sentence and making several comments in regard to the abhorrent nature of crime and its repulsive impact on society, would have also given due consideration to the equally relevant aspect pertaining to mitigating factors before arriving at a conclusion that option of any other punishment than the capital one was foreclosed. The approach of the trial court and the high court in this matter while awarding sentence could only be disapproved, and we do so in no uncertain terms. What has been observed and held herein above leaves us with the question as to whether in the present case capital punishment is called for or it should be substituted by any other sentence. The heinous nature of crime like that of present one is brutal rape and murder of a 7-year-old girl child definitely discloses aggravating circumstances, particularly when the manner of its commission shows depravity and shocks the conscience. But at the same time, it is noticeable that the appellant has no criminal antecedents, comes from a very poor socio-economic background, has a family comprising of wife, children, and aged father, and has unblemished jail conduct. When all these factors are added together, and it is also visualized that there is nothing on record to rule out the probability of reformation and rehabilitation of the appellant, in our view, it would be unsafe to treat this case as falling in rarest of rare category. Putting it differently, when the appellant is not shown to be a person having criminal antecedents and is not a hardened criminal, it cannot be said that there is no probability of him being reformed and rehabilitated. His unblemished jail conduct and having a family of wife, children, and aged father would also indicate towards the probability of his reformation. However, and even when the present case is taken to be not falling in the category of rarest of rare so as to acquire termination of the life of the appellant, yet the impact of the offences in question on the conscience of the society as a whole cannot be ignored. Thus, it appears just and proper to apply the course adopted in various cases involving the crimes of similar nature, where even while commuting capital punishment, this court has provided for life imprisonment without application of the provisions of premature release, remission before mandatory actual imprisonment for a substantial length of time. The appellant was about 33-34 years of age at the time of commission of crime in the year 2015. Looking to the overall facts and circumstances, in our view, it would be just and proper to award the punishment of imprisonment for life to the appellant for the offence under Section 302 IPC, while providing for actual imprisonment for a minimum period of 30 years. Having regard to the circumstances of this case and other punishments awarded to the appellant, it is also just and proper to provide that all the substantive sentences shall run concurrently.